don't know what to think of. So many things come to mind, but to put it into practical sense, what is that and
is Administration of Estates Act 66 of 1965.
Mhm.
So, and that's the act that basically explains the roles and the responsibility of the person that will execute or administer the deceased estate.
Mm. And why is it important that this process happens?
It's important because it really sets out all
Mm.
of the obligations and the procedures that must be followed by either an executor or the representative that is responsible to wind up a deceased estate.
Mm. And if you're wondering, how do we differentiate between the two? Worry not. We'll get into that part of the conversation with Alayna. Now, in terms of responsibility and sort of assigning someone or a place, who is responsible for reporting and where must this take place?
The person responsible is a representative is probably the person that you'd then go and register the report or lodge the deceased estate at the magistrate court. So it's amounts less than 125,000, but also amounts less than 250,000.
Okay.
So if the entire estate is less than 250,000, the master's office is either going to suggest, to the person responsible, go to the magistrate's court. It's an easier process.
Okay.
There's a lot less rules and procedures attached to that process. So we would advise, if it's a small estate, if there's nothing in the estate, then do by all means report it to the magistrate's court that has jurisdiction. That has district jurisdiction over the deceased.
Yeah.
Everything else above 250,000 must be lodged at the Master of the High I don't know how the listeners will, unless they're sitting with pen and paper, but I'll just canvas it. So the death notice is an essential document. The masters or the magistrates of the magistrates court will not accept the report as complete, or will not give you an estate number
Yeah.
unless you have these documents. And that's the death notice, that's the death certificate, that's the will, if there is a will. Remember we spoke last week, if
Yes.
there's no will, it would mean that the estate is wound up intestate succession. And then an inventory list. So an inventory list is just a document that sets out all the property of that deceased estate,
Yeah.
and then the nomination by the heirs for the executor. So there's a form where the heirs will then nominate an executor
Okay.
or a representative to represent the deceased estate, essentially. The identity documents of such persons, any marriage certificate or a declaration of marriage certificate document that would also be required to be completed. Usually when you nominate an executor or a representative, you'd nominate someone who's a close family member.
Okay.
And the masters or the magistrates court doesn't take issue with that. You do need to justify if it's outside of that realm, outside of family, and it's a close friend. The nominees would have to justify why they're nominating that person.
Yeah.
And I think the reason is just that there is a benefit attached to an executor
Yeah.
and a representative. They receive a percentage of the entire value of the estate, of course, but they must also be a competent individual,
Yeah.
because
And you
of,
mentioned this last week as well.
yes,
Yeah.
because of the requirements attached to what it is, that they need to do, how they need to lodge, all of those kind of things. You
duration of the entire process. But if you've just tuned in, we are talking to Alayna Leovendal, who's the managing director, of course, of Al Inc. It is called All Things Legal. It's a brand new series here on the CCFM Drive. And we are live on Facebook as well as YouTube. So feel free to send through your comment. That's on YouTube and Facebook. And of course, on
we have both case studies in our firm.
sure.
Some estates that we lodged took a couple of, or within a year, we could wind up the estate, but others not so long. I mean, we wait for letters of executorship for, I mean, there's some we're waiting for at least 2 years now.
Sure.
So when I say there's bureaucracy in the department, I really mean it, and I've experienced it. My
Yeah.
team has experienced it. We are frustrated, and so I can just imagine, what a person that doesn't have a legal background
Yeah. Yeah.
experiences.
Yeah. Completely foreign.
100%.
Yeah, sure. We've got, like I said, a few messages coming through. If it is just a mere comment on the topic at hand, we will gladly read it. But if it's a question, we will try and get into that question when we do our Q&A session. So, Mr. Clive Human, we see you, sir, as well as Angela. We will try and save those questions for that session. Now, let's talk about sort of once the deceased estate has been reported, everything's done, due diligence is done. What is the next step then from that?
Well, you'll receive an estate number,
Mhm.
and then the executor. Once it's reported, now you have to wait for the executor and the representative to be nominated.
Right.
Once letters of executorship or letters of authority is received, then sort of now you can actually begin the work.
Mm.
The first thing would be that that person who's responsible will have to collect, all of the property in their estate, at least know what the property is, make a list of it, and understand what is the value of the estate, what is in this estate. And then from there, you'll have to advertise within. In fact, I will say that you have to lodge within 14 days after the person has passed away.
Sure.
And once letters of executorship has been received, you'll have to advertise the estate for at least 30 days in the local newspaper or the government gazette. And then and that will be an opportunity for all creditors to lodge claims against the
Okay.
estate, so that, remember, you are collating the value of the estate, and you have to collate both assets and liabilities.
Mm.
And you can only understand liabilities once you've actually advertised the
Yeah.
estate. Once you know all of that, and you are able now to draw up a liquidation and distribution account. So that's just an account of the assets and the liabilities. This is what the estate will look like. You'll draft it, you'll give it to the family members, they'll get the input, and then you'll eventually take it to the masters, and the masters will have a look at it, and if they are happy and all of the questions are dealt with, then you again have to advertise the
Sheesh.
liquidation and distribution account, and that has to lie for about 21 days. You will then also open an interest-bearing bank account, and all of the monies, all of the property that you received, if there is property that must come to the estate, it will go into the interest-bearing account, and from that account, once the 21 days has expired, everybody is happy, the masters is satisfied, then you will give effect to all of the payments
Sure.
that the estate needs to comply with,
Right,
of course, and then
right.
the beneficiaries thereafter. The beneficiaries will then receive the residue of the estate.
It's such a lot of overwhelming information, but also things and a process in itself. So I can totally understand why you would sort of encourage people to either, hire a law firm, as you say, or a competent representative. There's so much to get into. I mean, and again, just latching back on our previous conversation, talking about the necessity of a will, because you want to make sure that this process then is smooth sailing, wouldn't you say?
100%, and it's also the document where you'll nominate
Yeah.
an executor. I've also dealt with estates where the reporting of the estate is sort of delayed because the beneficiaries or the heirs can't decide or
Sure.
agree on who to nominate as an executor. So, I mean, in the absence of a will, it could delay a
Yeah.
whole lot of other things. I mean, the master's office also, to be fair, I just want to mention this, to be fair, the master's office is not the only reason that matters are delayed. Sometimes it is the heirs, sometimes it's the lack of agreement, among the heirs, and sometimes there's interlocutory applications, and that's just like applications by someone who says, well, actually I have a claim, and then obviously that will delay the
Yeah.
process.
Yeah.
Or and the claim is being it's contested, you know. So there's a lot of things that can give rise to the delay outside of the master's office, but they don't always help, you know.
Hmm.
They're not as quick as I think they should be. There's been lots of discussion around the master's office getting to a place and space where, you know, they are more efficient, they are effectively assisting the public
Hmm.
in their legislative you know, prerogative, because this
Yeah.
is their mandate as an
Absolutely.
institution, you know.
Absolutely. Absolutely. Again, we see all the questions coming through. This is great, but we will save them. We'll save your names, and as we have the Q&A session with Alayna, we will try and maybe get onto to some of these questions. We are slowly going to wrap it up, but I also want to quickly jump to next week's conversation. I know that we're going to be touching on trust, and just sort of the financial implications therein. Without giving too much away, what can listeners expect from that conversation?
I think when does a trust, you know, suit your estate? I
Yeah.
mean, what we're really discussing is estate
Mm.
planning, and there isn't a one size fit all approach in this discussion. I mean, it really depends on what you want, you
Yeah.
know, and what works for your circumstances. And trust is a good platform, but it's not for everyone. And so we'd like to talk about, like, you know, in what circumstances is a trust
Mm.
appropriate, and what are the types of trusts that's available to an individual.
Mm, fantastic. I'm already excited now. So that's just a bit of a teaser, family, for you to tune in again next week, Tuesday, same time, right here on the CCFM Drive. Alayna, I do have to let you go, but for those that want to, or maybe they're thinking, listen, I want a law firm that will help me and I want to approach Al Inc. Where do they find you? How do they get in contact with you?
Well, as always, they can contact us on our WhatsApp number, or they can email us on hello at l-inc.co.za.
Fantastic. There you have it. And again, as we've mentioned, we were live. In fact, still are live on Facebook as well as YouTube. So if you want to re-listen to this conversation, you are more than welcome to download it, and to repost and to reshare with your loved ones. It's a brand new feature. We talk about all things legal, and we'll be touching on various sort of topics around the law, and also how it affects you as the citizen or even as a company. But it's all happening right here on the CCFM Drive. It's 17:37. Quick traffic update on the way. Thank you, Alayna.
My pleasure.